Yes, please.
My lord, may I be permitted to mention a matter?
Yes.
Item 10, your lordship remembers, your lordship has been kind enough to admit the appeal on last month,
Yes.
that is on 8th, and fixed today for hearing. But
Hearing?
probably today, my lord, as I heard from the learned senior advocate, Mr. Banerjee, his matter will take.
Yes.
So likely our matter will reach. So, my lord, what I am beseeching in presence of my learned senior friend, if your lordship kindly takes the matter or fix the matter on 18th and 19th, my lord, so that the matter can be heard at
Item number 10.
item 10, my lord.
10, 11
And
to
for
13, man.
10 to 30.
10 to 30.
30.
We are for the respondent number 4 in item 10.
Who's for the appellant?
This one.
My learned senior friend is here.
I'm for the state.
And yes.
We'll have one. Please help. We'll have. No, no.
Roof proofing is a successful tenderer.
Yes. No,
I was the successful tenderer, my lord.
that was.
I was awarded with a contract,
You are roof proofing.
power roofing.
Yes, power roofing.
Power roofing.
Yes, and I am for the respondent number 4, Manakchia.
They challenged, they were technically disqualified, my lord.
My lord,
I'll just give a brief. But here, whatever tender was issued, my lord.
The tender was set aside.
yes,
Now, I was awarded the contract. They were disqualified at the technical stage for non-submission of certain documents, my lord. They challenged the disqualification. What the learned single judge did, my lord, is set aside the entire tender process, directed for retendering the entire thing, my lord. Against this order, we have come.
and in that
Our case
judgment,
is, my
it
lord,
was-
that technical bid of the respondent was rightly rejected for non-submission of the earnest money deposit in the format that was prescribed under the NIT.
in the judgment, your lordship, subject to correction, the honorable single judge hold that so far the technical hurdles we have already crossed. And in the tender process which has been awarded, my lord, the minister takes the role which he ought not to.
Or
Instead
in
of
other words, wrongfully disqualified
Absolutely.
at
I'm
the
grateful. I'm
technical
grateful.
at the
Absolutely.
technical bid stage.
absolutely, absolutely.
But this is
And
only
all
one point in issue, my lord. It can be disposed of with a short hearing, my lord. Today or any date, my lord, subject to lordship's convenience.
Who's for the government?
I'm there, Your Lordship, for escape.
Have you floated a fresh tender?
Lordship, there.
Well, in fact, there is a order, my lord, order of 13/6/25, lordship kindly please, my lord.
What a type of the order?
13/6. The last two paragraphs.
May I pray, Your Lordship?
Where is the last one?
Where is the 13 June order?
13 June or that? 13 June, I'll ask her.
This order is in MCWA number 58, my lord.
The contract was awarded in your favor.
Yes, my lord.
awarded to tenderers, my lord.
Awarded to
My friend and my
two,
party.
because what happened, my lord, the prices of the appellant and his client, my lord, they were at par. So we were given 75% of the work and he was given 25% of the work, my lord.
And we challenge that action, my lord. My lord, it requires proper hearing.
Where is the 13 June order? Why in a separate folder? Miss.
ব্যাংকের ওটা বের করো, ব্যাংকের ক্লারিফিকেশনটা বের করো, এই পিছনে কোনটা আছে বের করো, ফটাফট আরে বের করো না। এটা 83, এটা 81। That is
Mr. Mitra, you are respondent number?
4. And my lord, subject to correction, when your lordship was pleased to admit the appeal, as it, my lord, transfers from the order, your lordship has been pleased to direct till admission of the appeals or until further orders, whichever is earlier. We simply extend the time for compliance of the impugned
Yes.
judgment on order.
We will say till disposal of the appeal.
Yes. So, my lord, that compliance part, my lord, so far fresh tender part is concerned, my lord, that has not been done. And already, my lord, in the judgment, impugned judgment passed by the honorable single judge, it has been observed that the technical, my lord, hurdles we are successfully crossed. So far, the bank deposits is concerned. It has been, my lord, categorically stated by the bank at page 83A of the paper book, which has been
Yes,
supplied.
please take down.
My lord.
These appeals have appeared today in the list for hearing. We have heard all appearing counsel. On the ambit and scope of this appeal. Paragraph. You are respondent number 4.
4, my lord.
In a writ petition, paragraph, in a writ petition filed by the respondent number 4, the works contract awarded by the respondent state in favor of the appellant
টেন্ডার ওটা বের করে রাখো পাতাটা 9,000
was cancelled by the impugned judgment and order dated 8th May 2025. Full stop.
9,000 টাকা দিয়ে আমরা
আমি জানি না।
It appears from the submission of Mr. Mitra, learned senior advocate appearing for the appellant, that the principal ground on which the learned judge appearing for respondent number 4, the principal ground on which the learned judge ruled in favor of his client, the writ petitioner, was that their technical bid was wrongfully ignored by the authorities considering the tender. at the technical bid stage. Paragraph. 18th,
My Lord, 18.
yes, we fix 18th August.
May I pray your lordship if the matter can be taken up on 28th, 20.
He has difficulty. 18th, sir, you have
Let us
difficulty.
have on 20 of August.
20th. Can it be 19th, my Lord?
19 also will do.
19th. 19 and 20, both the days, if your lordship kindly fix, so that after the completion of my learned senior friend, I can, my lord, complete by giving the reply.
No, then you take 27th and 28th. Before
27, yes.
Yes.
27.
My lord. My lord. Kindly fix, my lord, 27 and 28, my lord.
List these appeals for further hearing on 27th and 28th. We cannot fix it in that way, but we'll say fairly at the top.
Fairly at the top.
Yes.
And yes.
The interim order dated made on 13 June 2025 is slightly modified by directing that it would continue till disposal of the appeal or until further order, whichever is earlier.
Grateful, my lord. My lord, only one indulgence, my lord. Your lordship has been pleased to passing of the order record as myself as senior advocate. I am not a senior advocate, my lord. Till I am learning from the footsteps of senior advocates like Mr. Banerjee.
No, in the order sheet also it is recorded as senior
Yes, so
advocate.
that is not correct, my
No,
lord.
no, that
I have
they will
never
correct.
applied. Great. Great.
The nomenclature hardly matters. It is the quality of submissions which.
I'm deeply obliged. I'm deeply obliged.
That's item number 313, madam. It's all connected matters.
Yes.
Deeply open.
Deeply.
Item
Yes,
number 1.
Mr. Banerjee.
My lord, I was addressing your lordship on the question. The proposition I had advanced before my lord was this, that in the case of liquor particularly, the state can create not only a monopoly in itself, but can also delegate that monopoly to a third party. I have already cited one judgment, Coover G. I'll just give your lordships the paragraphs of Khode and the number plate case. Your lordship will just make a note of the reference and the page numbers. I'll read out the paragraph. Your lordship need not trouble. It's just one. The same proposition. Khode. Khode.
Yep.
Right. Khode. Yes.
You cited 54(1) SCC.
Yes. Now I'm citing, my lord, 1995 1 SCC 574. I've given your lordship that. Same proposition.
1995.
1 SCC. What do you have? Yes. You've cited also, I think. 1995 1 SCC 574. The summary of the law is at paragraph 60, at page 608 and 609. And subparagraph F. I'll just read that one subparagraph. At page, my lord, 609. For the same reason, my lords have it. For the subparagraph F, state can impose limitation restriction on the trade of business and portable liquor as a beverage, which restrictions are in nature different from those imposed on trade of business and legitimate goods and articles, which are res commercium. So res extra commercium, we can impose higher level of restrictions. The restrictions and limitations on the trade of business and portable liquor can be both under Article 19(6) or otherwise. The restrictions and limitations can extend to the state carrying on the trade or business itself to the exclusion or elimination of others, and or, this is the part I'm relying on, preserving to itself the right to sell licenses to do trade or business in the same to others. So not only can I have a state warehousing corporation, I can delegate that to somebody else. So summary of the law at subparagraph F. Very clear, my lord. As recent as 1995. And to the same extent is, my lord, the judgment in Association of Registration Plates versus Union of India, which is 2005 1 SCC 679. Absolutely clear, my lord. The law, it is not even, with very great respect to my learned friends, not even open for argument today that the state cannot create a private monopoly in any area of liquor. State can, by even as far back in Assam in the excise rules, your lordship has seen section 19 of the act, that is 100 years ago, there was exclusive monopoly to do business in countries which my learned friend relied on. It has always been the case. But now this cemented by the Supreme Court, the judgment. This is, yes. Oh yes, liquor. This is not a liquor case. This is the number plates, your lordship may know now. It started in Delhi all over. They have those special security number plates. Yeah. So when the security number plates came in, there was a lot of litigation as to who will get the contract for those number plates. So in that connection, one particular person was chosen, and paragraph 39, 40 and 44, this issue was there. Basically, the Supreme Court has said, provided you do it by public auction, there is no question of monopoly. The notice inviting tender, your lordship, I'll just read it out, is by all, and even if one single manufacturer is ultimately selected for a region or state, it cannot be said the state has created a monopoly of business in favor of a private party. So even in a non-liquor case, if you have a public auction and a single license, it cannot be said to have created a private. That's paragraph 39. 40. Selecting one manufacturer through a process of open competition is not creation of monopoly as contended in violation of 19(1)(g) of the Constitution, read with clause 6 of the said article. Paragraph 40. 39, 40, and my lord, ultimately at 44. 3 paragraphs. Same proposition. So it's not just liquor cases, any case. If the state wants to hold something by public auction and give it to one person for a particular area or for any, even without an area, that is not a monopoly, so long as you do it by public auction. That's the proposition in liquor, that's the proposition otherwise. So with greatest of respect, this law is very clear, and challenge on this ground must fail. If this is correct, then today also, if I want to give a liquor license for retail shop for the state, for the city of Shillong, I can't give it. I must give 100 or 50. I can't give one. This is the area of, entirely the area for the state's discretion, my lord. This cannot be the law. And the Supreme Court has said so in no uncertain terms. My lord, may I go on to the next question, which is, my lord, I will be relying on, I'm just prefacing it, a minority judgment of the Supreme Court. A minority judgment, I'm telling your lordship. The law is, I'll show your lordship in the Allahabad High Court. Supposing your lordships say in the Supreme Court there is a 5-judge bench. This is important, my lord, your lordship will kindly. 5-judge bench. 4 judges go one way on a particular point. The 5th judge disagrees. This judge's judgment has no value so far as it disagrees with this four. That's a simple proposition. However, if this judge decides, the fifth judge decides, issues which are not decided by the first four, or which the first four leave open, then the fifth judge's judgment also has the sanctity of law under Article 145 of the Constitution. The minority judgment on an issue which is not decided by the majority. For that, I'll just give you, in case it is argued that this is not the law, I don't anticipate it will be argued that this is not the law, but I don't want to again have to rejoin to the rejoinder. So I'm just giving a judgment in anticipation.
Have you cited any minority judgment?
I'm going to. Paragraph?
25.
Paragraph 25. Where is that, brother? Yes. My lord, I'll give your lordship the background in 2 minutes. Very interesting question rose before the Supreme Court. Article 15(5) of the Constitution. Whether or not to extend, see, the 15(5) introduced reservation for scheduled castes, scheduled tribes, and special categories in educational institutions. So, the question was for government institutions and for private unaided, completely private. So, what the Supreme Court said was, for government institutions, Article 15(5) is valid. I can reserve for scheduled caste, scheduled tribe in a government institution. But 4 judges of the Supreme Court said, we are not deciding whether for a private unaided institution, Article 15(5) reservation is possible. Am I clear? Judge number 5, Justice Bhandari, and the 4 judges said in their judgment. However, the 5th judge, Justice Bhandari, has taken a view on this, and Justice Bhandari decided. 4 judges said, we are not going into it. We are not deciding private unaided. We'll leave it for another day. 5th judge said, I'm going into it, and he decided that private unaided, it is invalid. Article 15(5) is invalid. Reservation is not possible for private unaided. That is the 5th judge. Allahabad High Court followed that judgment and said, this is also law because this is not in difference to the first 4. The first 4 left it open. 5th judge has decided this. We are following this. Paragraph 25 of the judgment of the Allahabad High Court. The division bench of the Allahabad High Court. May I read out the principle? It's an interesting proposition, my lord. When a court is divided, para 25, Lordship will kindly see this, my lord, because this is to preempt an argument that why are you citing a minority judgment? I'm deliberately pointing out what is the law. When the court is divided, the judgment of the majority constitutes the law declared, and not the view or observance of the judges in the minority, Vaidi, George Martin, etc. Where the majority has not expressed any opinion, the decision of the minority, even by a single judge, has the effect, if the reasons are given, of the judgment of the Supreme Court to be binding upon the High Court under Article 141 of the Constitution of India. The principle underlying the decision is binding on the High Courts. In Ashok Kumar Thakur, the Supreme Court, my lord, question answered by the Honorable Justice Dalveer Bhandari, namely whether the 93rd Amendment violates the basic structure of the Constitution by imposing reservation on unaided institutions, did arise in the case and was apparently argued by counsel appearing for the parties. The Honorable Judge posed the question and answered it by elaborate reasoning. He has not only answered the question, but in adopting the principle severability to the offending party, consciously declared that 93rd Amendment refers only to unaided institutions, ultraviolates the basic structure of the Constitution. The ratio of the decision is the binding precedent, and thus, etc., it refers, has been held to be ultraviolates. High courts are bound with the ratio as to follow it under Article 141, and on the same analogy, as 15(5) has been declared to violative on the right of occupation, the provisions of so-and-so, the UP Act have been struck down. So, what the Allahabad High Court did was to adopt the minority judgment of the Supreme Court on an issue where the majority had left it open. Clear to my lords. And I invite my lords also to the same thing in the judgment which I am going to cite. which is the judgment in international spirits, the very same petitioner before my Lord, and which deals with all the questions raised in this petition. All. At least 5 major points raised have been answered in this judgment. May I, without further delay, give your Lordship this judgment? This I'll have to place in detail because it is the most important judgment, and that quite coincidentally that is the same petitioner. That's not the importance. The importance is it covers most of the questions raised by my learned friend in this case.
But before you go to that, this
My
is
lord.
just out of academic interest.
My Lord.
We accept your submission that it
My Lord.
is binding.
My Lord.
Minority. When the majority says that we are not going into the issue,
Yes.
so that is not an issue by ruling of the majority before the court at all. So
It
any
is-
pronouncement on that
I appreciate your Lordship's
would
question.
be absolutely arbiter.
Your Lordship, it could have been said that this is not a decision which is vital for the decision of the case, therefore it is not ratio, it is obiter, and therefore it is not a part to be followed. But that reasoning has been repelled by the Allahabad High Court. It is part of the law of the land. It's a judgment of the Supreme Court under Article 140. That's why I cited it.
Yes.
It's a possible view. What your Lordship is, it's a possible
So
view.
it was-
But the Allahabad High Court has rightly held otherwise, because a judgment of the Supreme Court, even a minority judgment, is entitled to the greatest of respect. That's the point. Now, whether you call it binding precedent or greatest of respect or whatever, my lord, I am not quibbling about semantics. According to me, correct principles are laid down in this judgment of the Supreme Court, and there is no judgment of the Supreme Court which says otherwise. Put it in that fashion, my lord. So all the points which have been raised and argued have been decided by a judgment of the Supreme Court, and there is no contrary judgment of any High Court or Supreme Court on the subject. Lordship takes it in that sense. Allahabad High Court says it's binding law under Article 141.
Yes. That is why I said out of sheer academic
Yes,
interest.
out of academic
It was-
interest.
it
I
was-
personally believe that the Allahabad High Court view is also academically also correct, because law under Article 141 and 145(3) must be any judgment. That's the reasoning. Any judgment. Until and unless there is a contrary view which is overriding it. So if your lordships differ on a matter, neither of the views will be a judgment maybe, but if there are three judgments, your lordship, and one of the judges expresses a view on some other things, which your two or do not decide, that may be a law. So this is the academic question.
Yes.
But anyway, may I get into, so this is the Supreme Court. What had happened was, prior to this, I think Maharashtra, Maharashtra, right? Haryana. You could import, the suppliers like my learned friend could import liquor directly from abroad. So you got your black label directly from London or wherever, and different suppliers bought different brands from different parts of the world. Now what Haryana did was, all of this concentrated in one agency. Only that agency will import. And you take your stuff from that agency. Like your central warehousing, similar. Simple proposition. It was challenged on various grounds.
Yes.
I'll show your lordship. One ground on which it was challenged was that the particular notification could not be done by the state. It had to be done by the financial commissioner or not.
Yes.
So the majority, what they did on that ground, majority accepted the proposition that it was not to be done by the state, it could not have been done by the commissioner, should have been done by the state, and the majority struck it down straight away. Didn't get into any other point. Lordship is with me.
Yes.
On the power of the state. The minority judge, Justice Joseph, disagreed on that question. Said no, the government had the power to enact the notification. So now the minority judge had to consider the other objections. Your lordship sees, if I make 5 objections before my lord, and the first is sustained, your lordship will not necessarily go into the next 4.
Yes.
But if there are lordship 3 of you and 2 of you say I am sustaining the first objection, the third judge may go on to the next 4 because the third judge doesn't agree with you on the first point. So the third judge, the fifth judge here went into the other points argued. Now kindly see what were the other points argued before my lord, Justice Joseph, in Justice Joseph's judgment. Now starting at page 305. Very important, all the questions are, if not all, most of the questions are answered. Right, now, kindly starts at page, I'm not on conferment of powers. Up to 41, he disagrees with the majority judgment, and I would confirm the division bench that Financial Commissioner has the power. So the area of disagreement is at paragraph 41. Kindly comes paragraph 41. Whether the Commissioner has power or whether the state has power, there is a difference of opinion. Para 41. 42 onwards, my lord, I will place in detail because it's very vital. In fact, it covers about 5 days of my learned friend's argument. The answers are all here. 42. Having expressed, Lordship has it, my lord? Yes. Having expressed my disagreement with regard to the finding of the sole issue which has been dealt with in the majority judgment, I must necessarily proceed to consider the other two contentions which has been raised by the appellant. Appellant has contended as the rule leads to creation of monopoly and what is really objectionable in favor of a private party, it is contrary to the guarantee embedded under Article 19(1)(g) of the Constitution. Same question raised by my learned friend, which I have cited the other judgments. Same issue. The High Court has repelled this argument also. It relied upon the judgment in Khode Distilleries. Lordship has it? Yes. Wherein the court held as follows, Kuvarji versus Barucha. So Khode, Kuvarji, followed by the Supreme Court. I have already shown your Lordship both. Then kindly comes to the next page. The next page, Kuvarji is continued. Then paragraph 43, Maninderjit Singh Bitta versus Union of India, the license plate case. Paragraph 43. Third judgment which I gave to your Lordship. In this case, undoubtedly the rule provided there will be only one license. Right of the license was settled by e-tender. It was open to any person who is otherwise eligible to participate in the e-tender. Undoubtedly, the guarantee of fairness of state action and a taboo of arbitrariness must inform the state action. Once it decides to permit trade in liquor, it is to be noticed. Kindly take this line. This line is important, my lord. It is to be noticed that the introduction of the rule was primarily to earn maximum profit. The case of the state is that introduction of the rule has enabled collection of greater amounts by way of revenue. Lordship sees it?
Yes.
I am saying the same thing in my affidavit and in my letter. Identical reason given for justifying the policy. Same reason given. This cannot be said to be entirely an irrelevant consideration. So, very low threshold. Going too far in these matters may involve the court making a foray into the ordinarily forbidden territory of policy. My lord, I rely very heavily on this. I have said as the state that my policy is to maximize revenue. The court says this is not irrelevant and the court will not get into this area policy. That is to say, it is not open to argue, as my learned friend Mr. Paul argued, that in fact there is no loss of revenue because it's prepaid duty and all. This is not an area to get into. If I say it is for maximization of revenue, that has to be more or less accepted by the court. It's a legitimate consideration. That's paragraph 43. It's another matter that I have shown in my affidavit that the revenue has actually gone up in my additional application. No doubt, the appellant draws attention, recent decision in Kerala Bar. The first is prohibition, second is monopoly, third is to allow private players. So, my lord, Kerala Bar is cited. Nothing turns on Kerala Bar. Company comes to paragraph 46. 46.
So that is why I was asking you yesterday that whether the court can give directions with regard to...
I'll come to that. I'll come to that. Short of changing the policy direction, I'll come to that. I'll address your lordship and I'll suggest also certain things.
And in case it falls short of that, then the court will consider whether to declare that it is becoming ultra-virus the
Yes,
Constitution.
absolutely. I would submit the question which has been raised by my learned friends. They have not really asked for directions for your lordship.
No, they have not. But whether the court can
All right, if it is something falling from your lordship which they have not asked for, I'll deal with that definitely. I will give your lordship the parameters, what can be done according to me and what cannot be done. It is possible that in cases of some lacuna that can be filled up, I'll suggest what can be done before this court. I'll suggest that.
Lacuna we cannot fill up. We cannot.
I mean, let us say for more effective implementation, what your lordship is thinking, I'll give my suggestions, my lord, on that. But my first question is, my earnest endeavor is, my lord, that with great respect to your lordship's learned predecessor in whatever those sort of directions, margin of profit and all that fixation, my lord, that is completely outside the purview of legal interference in writ, and otherwise also unworkable. I'll make my submissions, because he will never get an agreement between two parties, private parties, to regulate the terms of their commerce. Whether the court will do that or not is a very serious question. So, your lordship, I'll make my suggestions on that, Mal. What can be done? I have conscious of your lordship's queries and the direction in which your lordship would like to go, and I'll deal with it all. I'll give your lordship all the parameters, my lord. What is possible, what is not possible, etc., etc. Essentially, I'll tell your lordship that two areas which are really, if I may say so, the thrust of the arguments of the petitioner and also the bonded warehouse. One is the question of shortage of supply and favoritism. Other is the area of excessive margin being charged. These are the two areas. I'll deal with what can be done. I think there is no third area. These are the two areas which cover the scope of their grievances commercially. And of course, the legal arguments are in support of striking down the policy, which are in aid of these ultimate commercial objectives. Because the policy is struck down, then according to them, supplies will improve and margins will improve, blah, blah, etc., etc. That will follow. I'll come to that. But now I'm dealing with some fundamental legal questions raised by my Mr. Shah. So I have to deal with them a lot. So number one, monopoly has followed. No question of monopoly. Number two, paragraph 46. This is the Supreme Court, my lord. Lordship was saying this is a very unfair and technical approach, but it is my duty to place it. Kindly cease. I don't say that your lordship will decide it only on this, though another bench might have done that. But kindly read it. Paragraph 46. I would not lose sight of the fact of this case, one dimension in this regard. The appellant is an association of companies. We are talking about this petitioner. Article 19 provides for various fundamental freedoms. However, unlike 14 and 21, these freedoms are not conferred on non-citizens. In other words, this is as recently as the 1995 judgment. In other words, Article 19 is confined to citizens. It's well settled that the company or juristic person, being not a natural person, is not a citizen within the meaning of Article 19. The writ petition is filed without joining any shareholder who is a citizen. This is what should have been done. I would also take the view that therefore reliance on Article 19 may not hold good. Paragraph 46 shuts out the petitioner from Article 19 altogether because he has not added a shareholder and he is not a citizen. I'm only placing it before your lordship. That's the law of the land according to me. So petition has to fail on this ground alone. That it is curable, I'm not debating. That he can maintain another petition on this ground, I'm not debating. Not contradicting. But as it stands today, paragraph 46. And if I may make this observation, you international spirits have gone to the Supreme Court. A Supreme Court judge has said that your framing of the petition is wrong. You nevertheless do not change the structure and framing of the petition. You nevertheless make the same defect and come before this court. My lord, why would the court not follow this observation at paragraph 19? Paragraph 46. I do not press it beyond that. Now, next question. 47. Judicial review of policy is justified only if the policy is arbitrary, unfair, violate a fundamental. Courts must be loath to venture an evaluation of state policy, etc., etc. Yes. Now, 48 is very important. The next ground my learned friend took. The assumption of monopolistic position by the licensee would lead to arbitrary, unfair practices which would leave members of the appellant without redress. The High Court has rejected the contention by reasoning the licensee, so long as it confirms the condition of law, is a free agent, shut out the judicial review. This is what the High Court finds. Then the entire reasoning at paragraph 40. There is no doubt wholesaler in the...
Mr. Banerjee,
Yes.
we have a full court at 2 o'clock today.
I have no problem, my lord, but then I will need a certain amount of time. I wanted to conclude on Monday, so it will be difficult then. I need a little more time.
Yes, how much vote?
I will need, my lord, a total time of about an hour and a half to conclude. Today and on Monday. Your lordship, 1.5 hours, your lordship gives me, I'll complete.
Monday you're available?
Monday I can come, Tuesday I have a problem. So if it's not on Monday, it'll have to be on Wednesday. So lordship may make it on Monday and Wednesday or Wednesday and Thursday, whichever your lordship.
Which is convenient for you?
I think Wednesday and Thursday is better, my lord. Then I can go back and come. Your lordship gives me 1.5 hours, I will maybe earlier. Today I got only about half an hour.
That is 13th, 14th.
13th, 14th.
Alright.
Grateful.
13th, 14th.
Grateful.
Lordship will give this the priority, my lord. I
it-
want to finish this, my lord. I understand your lordship's urgency.
Right.
Item 4 and 5.
More matters.
Yeah.
You prepared an order, huh? Same. Mr. Banerjee, have you tried that direct Delhi Shillong flight? No. I think
It's risky. I've done it once, but it's a bit risky. It keeps getting cancelled. I would like to try it, but
it gets.
I think the AG has tried it. I don't know how it. It is much better. It saves a lot of time, but
I have tried once. It's very convenient also. Traveling
No, but
time is saved.
No, but
does it work? But still, does it work?
or is it comfortable in the air?
It's not, it's choppy, sir. It's a choppy, it's a turbulent.
How many
turbulent.
seaters? 70.
It's a middle-sized aircraft,
Yeah.
not the big one.
Perhaps the same which flies from Calcutta to Shillong.
Yeah, same.
That this is Indigo, that is SpiceJet. Yes, Mr. Dotto.
My lord, yesterday your lordship had asked me about the whether the substance I was arguing whether it was pleaded in my rejoinder or not, my lord. My lord, that has been done, my lord, in paragraph 4C. If your lordship will kindly see the paragraph at page 6, my lord. 4C, my lord, this has been said that prior
It
to
doesn't matter.
Yes.
If it is there in the letter, if the letter is 6 June,
yes,
so the subject to observance of certain formalities,
yes.
it is highly
Improbable.
surprising how it could start on, how the work could start on 6 June itself.
Yes. So that is
For
one
that,
thing.
you don't need any affidavit. The records will speak for itself.
Yes, my lord, that I have highlighted here. And now coming back to the other affidavit which my learned friend for the writ appellant Taibin Varjiri has filed. There, my lord, your lordship will find they have enclosed certain vouchers to Contempt that these vouchers are proof of the fact that they have undertaken the work and they have conducted it to some extent. Now, two dates, my lord, I would urge your lordship to take note of. The Honorable Single Judge had reserved the judgment in the writ petition on 22nd of May. Right? Honorable Single Judge has reserved the judgment on 22nd of May and the judgment was delivered on 5th of June. Now the vouchers that they have produced in support of their contention that they had purchased material and undertaken the work, those are at page 5, 6, 7 onwards, my lord, in their affidavits, and the dates are very interesting. The dates are of 31st, starting from 31st of May, 4th of June, 7th of June, which goes beyond the date expressed by the MEPGCL as to the date of closure. MEPGCL says that 5th of June the work came to an end. And the vouchers that have been annexed to the affidavit, my lord, these are of 6th of June, 7th of June, 4th of June, and one of 31st of May.
Work came to an end.
Lordship?
Work came to an end.
Yes,
It was
they stopped. They have used the expression, the work was stopped.
Yes.
Stopped on 5th of June, according to MEPGCL. Whereas the vouchers produced by the appellant Taibin Barjari are of date 6th of June, 7th of June and onwards. Except one, which is of 31st of May. And that is after the Honorable Single Judge has reserved the judgment. The judgment was reserved on 22nd of May and it was pronounced on 5th of June. So this is also in my respectful submission something disturbing which do not inspire confidence that whatever have been stated before the court on affidavits, my lord.
No, in the judgment, they were asked to stop the work.
No, in the judgment, my lord, the initial observations were that settlement will be subject to the outcome. Secondly, execution of the work will be subject to the outcome. Two observations were made on two different dates. And that was passed way back in the month of April. And finally, my lord, the tender was cancelled.
No, but what is wrong with the invoices before the judgment?
There is only one invoice before the judgment. All the other invoices are after the judgment. After the tender was, according to them, after the work was stopped. The MEPGCL says that the work was stopped on 5th of June and the vouchers are of 6th of June, 7th of June and onwards. And last voucher is of 10th of June. So, my lord, to contend that on the strength of these vouchers they had produced, procured materials and did the work, my lord, that is very doubtful. And along with that, my lord, the content of the affidavit, as I said, my lord, that do not inspire confidence at all. Now, one very important aspect has fallen from your lordships, my lord, that in a circumstance of this nature, whether an equitable consideration can be given to them, particularly in view of the fact that notwithstanding the orders of the court.
No, not is that. Mr. Datto, you try to develop that, at least in my prima facie view, that is your strongest point. Your strongest point is that it came down to this level that the tendering authority called, because all were same offer, XXXX.
Yes.
That all of you come for some kind of a negotiation. Yours was 1 rupee more.
Yes.
All right.
Yes.
Why were you not called?
Yes. That is one point. And to that point, my lord, their only answer is that.
And all right, they were the lowest, they were called. So when they were called, 3 out of 4 backed out.
Backed out.
All right. Before awarding the contract to the 4th,
yes,
whether or not it was the obligation,
yes,
duty,
yes,
or fairness demanded that the +1
one should also be asked for,
and if necessary put them into an auction.
Yes, that is one case. Now on that point, my lord, I had cited the judgment of the Honorable Supreme Court in the case of Datta Enterprises, where the Honorable Supreme Court had laid down that if you adopt some modalities about which there is no disclosure in the tender conditions, then that will be bad. Now, this is a modality you have adopted. Maybe in all fairness, you have adopted a modality that I'll call all the parties.
It may have been very fair and transparent to have proceeded in that way.
Yes.
But however, proceeding the way they have done,
yes, that is not.
They have called only the amongst the with similar
yes
offers is not an illegality.
No, but it may not be an illegality, my lord. But my lord, as I understand the import of that judgment, my lord, that may not be an illegality. But
therefore,
that will not be.
Therefore, whether it can only be held that it's a lost opportunity for you, for which you can be compensated with some damages.
Now, there, I'll like to make some submission, my lord.
A legitimate expectation,
yes,
which was not fulfilled.
Not fulfilled.
For which you can be compensated in some measure
Some
of
measure.
damages
Now-
without disturbing the contract awarded in favor of Mrs. Parveen's client.
Yes. Now, my lord, there will be, in my respectful submission, two situations. First of all, my lord, the Honorable Court has to come to a finding that because of the modalities that they had approached, some amount of depravity has occasioned to me.
Yes.
Number one. And if that depravity has occasioned, whether on equitable consideration, my lord, it can be decided in such a manner that he will carry out the work, whatever is left out, and I will be compensated by way of money. That is how I understand it, my lord.
To some extent.
Yes.
For lost opportunity or denial of legitimate expectation.
Yes. So in that circumstance, my lord, whether on equitable, the equitable consideration can be invoked so as to allow him to proceed ahead with the work and at the same time compensating me with the monetary compensation.
Or, as you have prayed for, cancel the contract in their favor
Yes.
and give it to you to start the work de novo, which would be more equitable or rather fair order to be passed by the court.
My lord, with your lordship's permission, I can also suggest another angle to it, my lord. Not only to that extent that cancel the work order in his favor and allow me to do the rest. I would not even, that will be in my submission, my lord, that will be an extreme. Since the tender conditions itself say that the entire work can be divided into more than one successful bidders. Because possibly they had also something in imagination that there can be a tie. So if your lordship is considering a situation that minus that 1 rupee difference, all are at tie. So a possible solution can also be struck out in the sense that 50% of the work will be done by him and 50% will be done by me. Even the tender conditions support that situation, my lord. There is a specific, in two places, my lord, in the entire of the tender conditions, this has been repeated, that the entire work is capable of being divided between the number of the bidders, more than one bidder. So that is also one kind of a solution, my lord, that is possible.
No, we had a matter today morning where it was divided into two parts.
Yes.
Dr. Mazika one part and another part.
Yes. That is also one kind of a solution. That he, as per the, assuming for a moment, my lord, that whatever MEPG has said, that is correct, that they have carried out construction to the extent of 7%. It can still be saved, my lord, that, well, you do 40%, 50% of the work and the rest 50% be done by him, done by this writ petitioner. Now, on the equitable consideration, my lord, subject to your lordship's test, of course, my lord, I would like to place certain judgments. The basic principle that I am trying to put before your lordship is that, my lord, this equitable consideration can be given to them only when if your lordship finds that they are not tainted. If your lordship forms an opinion that in whatsoever manner there is a deviation from the terms and conditions of the contract and the settlement was done in some deviation of the requirements of fairness, then, my lord, that equitable consideration will not go to their favor.
Then what will be the court order?
Now, in that case, my lord, the honorable single judge's order has to be upheld. That the work order is cancelled, and as a matter of fact, my lord, as it transpired before the honorable single judge, there was a noting in the file that looking at the position of tie, the MEPGCL themselves decided that they will scrap the tender and go for a fresh tender.
So there would be no difficulty had the percentage of work done was very marginal, 0 or something, nothing had been done.
No, my lord, 7% is not also, my lord, in my submission, my lord, that is also not too substantial.
That is why we made that inquiry.
Yes. Now, question is that
here there are only 4 or 5 contractors.
Now,
yes, start a fresh bid.
Now, it is also contingent upon two conditions, my lord. You have carried out the construction, or rather the MEPGCL had allowed them to go ahead with the construction, knowing fully well that the matter is sub judice and 2 orders are there of the honorable single judge saying that it will be subject to outcome. And you do not participate, at that point of also time, you do not participate in the proceeding.
All right, Mr. Datta, we have a full court at 2 o'clock. We have a full court. So what time, when would you be next available?
My lord,
online, offline, whatever.
From 20th, if your lordship just gives me 30 minutes, my lord, I'll wrap up everything, my lord. I don't have much to say on this point. Only
yes,
to cite
Mr.
the
Banya?
decisions.
Anytime, my lords. I am available.
You make it before 20th one day.
Some my friend says there are some matters on 19th. So that's why. I'll
Wait.
come in the evening, Lord, 19th, 2021, your Lord, if your Lordship just accommodates me. I'll just place the judgment.
2021, there is some difficulty, personal difficulty.
Oh. Okay. No, the court has difficulty. 22nd in that case.
No, don't take it there.
But practically, my Lord, 3 days I am, this week, 3 days I am here, my Lord. That's why something I've piled up there. that is the problem.
Monday you are there.
Monday and Tuesday I am there. Next week, my Lord, next entire week I am there, my Lord. Because
It would be well possible online.
that will be difficult. Lord, now with the arrival of the Honorable Chief Justice, Lord, all the backlog cases have started being posted. So that becomes
18th?
My Lord, in that case, can it be on 19th? I'll try to I'll try to squeeze something, my Lord, 19th. Because 18th I am stuck up, my Lord, there. In fact, 19th also, my Lord, I am stuck up, but still.
No, then after 19th, to 25th would be all right?
Yes. That week is absolutely fine.
25th, 26th
Yes.
for further hearing. As the first matter in the list.
I am deeply obliged.
Obliged.